The next case involves an evidentiary faux pas. One thing about appeals that potentially can be deceptive is the fact that all your evidence goes into the record. But just because it's in the appellate record, does that mean that it's evidence that can be relied on by the Court of Appeal? The answer is no, not necessarily, as the appellant learned in the case Epstein versus Prescott Neighborhood Partners, LLC. The trial court in that case had dismissed plaintiff's complaint on an anti-SLAPP motion under Code of Civil Procedure section 425.16. The trial court also refused to admit the plaintiff's evidence in opposition to the motion, but the plaintiff failed to challenge the trial court's adverse evidentiary rulings. Instead, the plaintiff simply proceeded on appeal to rely on that evidence as if it had been in the record as admitted. That won't work, the court said. We can consider only the admitted evidence, and plaintiffs have forfeited any argument that the evidence they unsuccessfully sought to introduce established a probability that their claims would succeed.
You know, there's an interesting lesson there. I've done over 150 appeals. I've raised evidentiary objections and the failure to grant them or improperly denying them, etc., on appeal. And I don't think I have ever gotten a court of appeal to find that a trial court abused its discretion on an evidentiary ruling. So it's an interesting hypothetical point, and I will continue to press trial lawyers to make objections and to seek rulings on those objections. But I have to say, I can't remember it actually ever impacting my one of my appeals.
Well, but the issue here was, I think, that there was the appellant didn't even raise the question that there was some kind of impropriety by the trial court in refusing to admit evidence. It just treated the issue as a fait accompli, I guess.
Absolutely. You know, it's borderline malpractice, I would say, not to raise that issue. If all the evidence was excluded on the motion you are appealing, you should absolutely raise the issue. But I was just commenting in practice, it's
True.
A difficult burden to show abuse of discretion.
True. But then you have to make that, you have to give that explanation to your client afterwards and explain that, well, even had I made that argument, the Court of Appeal wouldn't have accepted it anyway.
Right.
So you're left with this, to use my analogy again, you're left with this bad yearbook photo showing you in the bad light.
Right.